So hi folks, it's Alex Woods here, vlogging to you about civil litigation, the county courts of England and Wales. I just wanted to do a little vlog on some key litigation tips. This is because myself and Daria, who've been running a lot of cases actually in the last 3 to 6 months, we've had an increase in the number of inquiries and clients and so on. And we're getting some reasonably good visibility on, on the key issues that face litigants in person, such as your good self. So this is going to be a whistle-stop tour around what I think are, just key areas or sticking points for people as they're running their own case or defending their own cases in the county courts of England and Wales. But if you want us to go into detail, dive more deeply into any one of these topics, then ping us an email, and whoever pings the most gets, or rather the greatest number of pingers will get their topic up next. So that being said, I'll just run through all these key topic areas. Firstly, discontinuance. Now, discontinuance has to be handled with care. A lot of people, and this is a problem generally, bring a claim that's a little bit half-baked or ill thought out, or at risk of being exposed to strikeout and so on and so forth. And so the person having issued the claim then wants to, get out of the fight, to retreat. Perfectly respectable thing to do in the commercial world. That's the approach you should take towards your litigation. It's a commercial endeavour, and if you've seen a defence, you may feel, hang on, our case isn't as strong as we thought it was, and so we want to retreat, we want to pull out or discontinue, to give it its technical term under the civil procedure rules. The thing to say is, you want to be discontinuing from a position of strength. So actually this is an area, in fact, although the last thing you want to be doing at such a point is spending money on lawyers, where a courtwingman or any law firm could be a value for money, if it's a high value claim. Most importantly, if you think you're being exposed to a large amount of your opponent's costs. So discontinuing where your opponent is another litigant in person, the financial exposure probably isn't that great. But discontinuing where, you're up against an opponent with expensive lawyers, and let's say there's been a lot of pre-issue correspondence, negotiation and so on, that bill could be quite high. So it's a kind of a game of finesse. Probing, assessing what the other side's costs are likely to be, because under the civil procedure rules, if you discontinue, you will be liable for your opponent's costs. So I'll say no more than that, but I do think that if you have a reasonably high value claim and your opponents are legally represented, it is definitely not throwing good money after bad to speak to a lawyer as to how best to, put up the white flag, so to speak. Because if you look weak and just write to the other side and say, we're going to discontinue our claim, they will then, you'll then be ceding quite a big advantage to them. And they will milk you for every bit of costs that you can get, and they will try and maximise, set it as very highest, the quantum of the claim. And remember, costs are kind of a movable feast, depending on which track you're on and so on and so forth. And most lawyers will expect to take a hit on costs even if they win. It could be 25%, could be even more. So you want to be thinking about, well, maybe I'll make them a global offer to discontinue, with each side, bearing their own costs or something of that nature. So Be careful about discontinuance. You probably need a litigation expert's advice on how best to do it and how to be remaining strong whilst you do it. Now, the next one is no win, no fee. No win, no fee is commonplace in the personal injury sector. Yeah, in other sectors it's not, and therefore you're not going to find many lawyers who will represent you no win, no fee. That being said, those that will number one want you to will want to know that the case is strong enough that, you know, it's got prospects of winning, so they'll get paid from the pot of money at the end. That means two things. One, it's a case where there is a pot of money at the end. You know, it's not just a claim for, I don't know, a boundary dispute, for example, or, you know, some sort of injunction. It's or a small value claim. It's going to need to have a sufficient amount of an asset, an award that's going to be able to be realised, and the lawyers paid their share. 25% could be more if it's small asset, could be less if it is a very big asset. So that's the first thing. The other thing is that they are not going to want to, you know, sign you up on a no win, no fee retainer unless they're reasonably confident that it is going to win a reasonable amount of money. And for that, they're probably going to want counsel's advice, which could be expensive. Yeah, you may want after the event insurance protecting you against having to pay your opponent's legal fees if you lose. So you're going to have to invest in the non-personal injury sector. The vast majority of law firms, many of whom won't even touch no win, no fee, you're going to have to invest at the beginning of the litigation. You're going to have to put money down, perhaps even up to, you know, issue and just thereafter, so that your lawyers can see what the defence really is, what the strength of the opponent's case really is, and then say, okay, we'll take the risk. So you kind of need a war chest even with no win, no fee, or at least a mini war chest. Breaking court rules, this is funny. Me and Dara have been running a bit of heavy duty litigation, a wills dispute, property dispute case, and the opponent is unrepresented, a litigant in person. So what's astonishing to us is how much rope the court gives her. The defence wasn't, complete, wasn't fit for purpose. Under the CPR, it was ripe for strikeout. You know, deadlines, court deadlines are missed, excuses are made, hearings are vacated due to illness. Judges keep changing. It's at the central London County Court, which is horrendously busy, and litigation's taking so long to get through that particular court. So I'm not meant to say it because I'm an officer of the court as a solicitor, but quite frankly, litigants in person can get away with murder in terms of breaching the rules. It's almost an advantage not to have a legal representation, because when you have legal representation, all these delays that are being caused by the litigant in person, playing a bit tricksy with the system, are kind of playing into our hands, because it puts our client's legal bill up. We have to have another hearing, we have to send the barrister a second time, and although ultimately we're quietly confident that we will win, the client is having to cash flow his legal fees against the litigant in person. because of all these breaches of the rules. And it's just the case that the judges, you know, it's quite easy to play the pity card in court with judges. You know, judges won't have read the case in full. They don't really know that the opponent is playing a bit tricksy with the system, because they haven't got time to read up on the whole case. They've got 30 minutes to read a bunch of papers before they go into a hearing, and it might be a different judge each time. So I find myself saying very reluctantly, because of course there are exceptions, that you can get away with murder as a litigant in person. I mean, I meant to give you proper down the line advice here and, you know, say what I see. And I see litigants in person getting away with murder. Next thing is, and this is where litigants in person don't get away with murder in respect of a flagrant breach of court rules, is when they first issue a claim. This is really a 180-degree flip on what I've just been saying. We're finding, Darius is finding quite a lot of people coming to us having done money claims online and kind of just incorrectly or hurriedly filled in the box on what their claim is, and then issued, and then being faced with the prospect of a strikeout application and the costs that are associated with that, often before it's been allocated to a track, so that if it's a small claim they risk getting a cost bill against them. Or the judge going after them and telling them they've got to go away and completely amend their particulars of claim, and then they've got to get a lawyer on board to do a proper job, and a lot of delay and cost is thereby incurred. Anyway, Dara was at pains to ask me to talk about this today, because we're seeing quite a lot of people come to us with ill-prepared particulars of claim. Now, if it's a low-value claim, you know, under 5,000 or 3,000, then okay, fill in the box, you know, and let the judge figure out the law. But if it's a slightly higher claim, or even if it's in a complex area like financial mis-selling litigation, for example, then you really are, throwing the dice if you don't properly particularize your claim. It's a matter of common sense, yeah? If you fail to prepare, you prepare to fail. If you're going to get things wrong after you've got the plane in the air, yeah? But then it's not such a big deal. Anyone can manage a bit of turbulence. But, you know, when you're launching the plane, you've got to be focused, you've got to have all the controls in place, and you've got to put a lot of energy and often some money into it in order to get it launched. Because if you don't, you just build fault into your case, into the litigation. It's also kind of a legal issue. If it's a simple contract claim, you know, breach of contract, well then you don't need to take too much care of the claim. So slight caveat to what I said, it could be quite high value, but it's a simple contract claim. You bought a yacht and the engine broke, you know, so you want your money back. And it's a breach of contract because you bought the yacht thinking that, being told that the engine was working. It's a motor yacht in this case. So, you know, it's not just about the claim value, although obviously if you've got a yacht claim, you probably can and should pay lawyers to fight it, because it then becomes more commercially viable, doesn't it, if you're going to win a large amount of money, because the lawyer's fees is a much smaller percentage. But, you know, and if you don't want to pay a lawyer to draft up a proper particulars of claim, then use the courtwingman service, do it yourself and get us to review it, or get us to draft it. We won't go on court record, we're just, you know, drafting that particulars of claim for you. Or, you know, I've done a video on drafting particulars of claim, and I've written a book, ka-ching. So, but please, don't just in a hurry, in an angry hurry, because you've been wronged, fill in that box, kick it off and think, well, it's done and the court will sort it out. No, the court won't sort out a incorrectly plead particulars of claim, particularly where it might be a tricksy cause of action, of which there are many. Unreasonable conduct is the next topic. You can, in the small claims court, costs are left out, yeah? But people often use lawyers in the small claims court or have to incur other costs. And, the general rule is that certainly as far as legal costs are concerned, each party bears their own. In other words, if you win, you don't get your costs paid, your legal costs paid by your opponent, which overturns the general rule of litigation. But if you can make a case that your opponent has behaved unreasonably, then you can get your costs. And the judge may well want to award your costs in those circumstances. So that then begs the question, well, what does unreasonable conduct mean? What it doesn't mean is just, this is my opponent's defence is unreasonable. He drove his lawnmower into my greenhouse and caused me £15,000 worth of damage and squashed the prize pumpkin that I was getting ready for the next, Dorset and Devon garden show. Right mess it was, and I probably would have won that competition, and my claim value is probably worth 50 or 100,000. Litigants in person love to set their claims all the way to the moon in terms of the quantum. Bless you lot. But why not? Ask for more, eh? The court can only give you less. So just because your opponent is an idiot doesn't mean that qualifies as unreasonable conduct. So in other words, it's got a special kind of rarefied definition, a legal definition. It's not just your opponent behaving unreasonably, because nearly everyone does behave unreasonably at one point during the course of litigation, because they get so wedded to their position and they think the other client is just being totally unreasonable. So what does it mean? Typical areas, and you can look, just Google this and you'll find law firms and barrister chambers will refer you to relevant case law on what unreasonable conduct is. In our experience, it's things like dishonesty. It's things like bringing a claim when when it's actually really weak and you're just it's just a vexatious type of claim. That would be unreasonable conduct. Unreasonable conduct could be breaching, repeatedly breaching, though, court rules. Yeah, that definitely could be unreasonable. An appeal from a very clear judgment could qualify as unreasonable conduct. We've got a case just recently where our opponents, litigants in person, only paid us £300 for the entire course of the litigation. They bought the book. We gave them some email support along the way for free because they were good clients. It was an interesting case, and they won the case against an opponent who was legally represented in a complex claim of six figures in value. So it can be done, folks, even in complex claims. And they then went on to have the judgment appealed by their opponent's lawyers, and at that appeal hearing, they won. The appeal was thrown out, and in fact the judge went after the other side's barristers for bringing the appeal in the first place. You could see how that might then lead to unreasonable conduct. Now, that case was on the multi-track, so not a small claim, but hopefully that gives you a flavour of what unreasonable conduct means. Now, I neatly segue into whether litigants in person can run multi-clap, or even multi-track claims. And as I say, we've had a client successfully do so. I really love it, although it doesn't make us particularly rich. I really love it when clients read the book and then they judiciously use this. They use courtwingman in the way it's meant to be used, you know, when they're preparing the statement of case, you know, perhaps a little bit of advice, or they want input on some trial procedure or disclosure issues or whatever, but only as and when they really need it do they approach us for advice. And yes, it can be done. And there's another client who had a university type claim. They'd deprived him of a year's worth of studies. I've actually forgotten the precise details, but it was a claim brought by a student against a university. We've had a few of these actually, and it was brilliant. He was just professional, competent, young, and he just used this judiciously, and he settled. That didn't go all the way to trial. He settled his claim, and he was happy with the settlement. So it's really interesting. If you're prepared to put in the work and, you know, be forensic, and most importantly, these clients were very, I'm sure underneath they were feeling it, but the way they presented themselves to us was always, you know, polite and professional, and with attention to detail in respect of the paperwork. And those are the sorts of people who win. So although generally in a multi-track claim, I should say a multi-track claim where there is some complexity, like a cohabitation, property dispute, or contested will, those areas I would advise that you just have to use lawyers. But there's no one-size-fits-all rule here. I'm looking forward to the time when someone runs their own contested wills case or cohabitation property dispute case with limited legal support and achieves a result. It must be possible. So, complexity. I think the answer to that question is where it is a multi-track complex claim, the best thing to do is to use legal advice judiciously if you just can't afford a lawyer and you decide that the claim is worth pursuing. Can I get my own costs as a litigant in person and at what rate? Well, it's interesting that, because I mentioned this case that's just finished. We just got the news a couple of days ago that the appeal had been thrown out, and the client wants to talk to us about costs. Because one of the valuable contributions we were able to make is to educate the client about costs, because it seems to be in that case there's a sort of a strong argument along the lines of unreasonable conduct, although it's not a small claim, that our opponent has just behaved badly, has been unnecessarily kind of irrational and unreasonable in the way that they've managed these proceedings. They probably have turned their nose up at what were decent settlement offers, so decent offers put forward by our client during the course of proceedings. That's one area where we can add value, by the way, is making sure people are making offers at the right time, because if you don't, it can hit you with costs down the track. It seems to me that this might be a case where a litigant in person can get more than I think it's £19 an hour now is sort of the standard hourly rate that a judge would award a litigant in person for their costs. It can never be more than a third of what a lawyer would charge. It's usually about 19. But when you think about it, the law says it could be up to a third. So it could be £100 an hour. And this is one case where, you know, good lawyering could make a case to the cost court, and we might use our specialist cost lawyers here to argue for a much higher hourly rate, because it's only reasonable when you think about it. If you have, sacrificed so much time running the litigation on your own, that if you were in a high-paying hourly job, you have lost the opportunity, you have lost whatever hourly rate you were on in that high pay, high, what am I trying to say? high-paying hourly rate job, or if you're a businessman who wasn't able to attend to his business, etc. It's much easier where you're a fellow professional, let's say, because then you can then prove to the judge that on that whole day you couldn't do any coaching, counselling, or accountancy, finance, legal work, and that's your usual day when you do legal work, and you could have worked 8 hours and that would have earned you £800, £100 an hour, something. Do you see what I mean? It's more easy to evidence your losses in those instances, but it's not impossible in other cases. And the case law says that allows litigants in person to claim, if they can prove, and usually in, if not exceptional, the rarer, cases, an hourly rate that's above that £19 threshold. So yes, the answer is you can get your own costs. You should ask. If you don't ask, you don't get. And you should also look into whether or not there might be a chance of you getting a much higher hourly rate because of the actual losses caused to you by all the time you spent running the litigation. Do I have to mediate, and if so, when? You pretty much do have to mediate, or you don't have to mediate, but you have to be willing to mediate and accept an invitation if it comes from the other side, and probably make one yourself in litigation these days. There's been a sea change over the past few years, and it's courts can now order parties to mediate, and it's now just, I guess they just want to reduce the backlog in the county court system and drive everyone down a mediation track instead. So you pretty much do have to mediate, but the real question is when. On the small claims, you get offered a court clerk on the phone. Yeah, what do you offer? What do you offer? Let's meet in the middle type of thing. Small claims mediation, you should probably tick that box on your directions questionnaire. But for other cases, because a small claim can't justify, a very small claim can't justify the expense of a mediator's cost, because it could be a day's mediation or even a half day's mediation can be quite expensive, in the thousands. So the question then is, well, when do you mediate? That for me is the important question. We've got a case where we're refusing to mediate pre-issue. So I think if you're a claimant, you'll often find that what happens now is defendants use the new mediation climate to try and evade and avoid and send you down a rabbit hole, try and stop you from issuing by offering mediation, so they use it as a tactic. They use this new mediation climate as a way of throwing a spanner in the works if you're actually bringing a claim. One of the best ways of defending a claim is simply to soft bat it into the long grass. Kick that can down the road, and the court system helps defendants because it is understaffed and under-resourced. So I sometimes say to my clients, look, you've just got to bite the bullet, show some nerve and issue, and then mediate after issue, because what we find a lot of people are coming to us having spent ridiculous amounts of money on lawyers. Commonplace to see 5 figures legal, and the case hasn't even been issued yet, and it's been years, because it's very convenient for lawyers when you think about it. A lawyer can say to the client, oh, you better try and mediate, let's negotiate, let's write another letter, let's have another conference, let's get barrister's advice, da-di-da-di-da-di-da-di-da. All the time they are meeting their monthly invoicing targets, because most corporate companies the corporation is driving, profits are driving everything, aren't they? And so you might have a very principled lawyer, but he has to hit his litigation invoicing deadlines each month, or he doesn't get his bonus. So you can see how the legal system too, the profession too, It suits them very nicely to have you go round in circles and keep paying their invoices and never issue, because they don't want to take any risk. Because if they say, look, just bite the bullet and issue, like I've said recently with a client, because you're just spending, because your opponent is not going to start and take notice until you do. And you're not going to be in a strong negotiating position until you do. Sometimes you have to, pick up the gun and hold it to your opponent's head, frankly. And so I say it's just not commercial. It just makes no commercial sense. You're spending all this money going around in circles, and you're not, and it's not just money. It's also just delaying proceedings. And when you delay proceedings, unexpected things happen. People go bankrupt, leave the country, die, God forbid, find some other excuse. Just delaying a bit of a dispute itself can make it difficult for an opponent to bring a case. Limitations, yeah. So be very careful. I actually do find myself, and I guess I must be in the minority, advising clients, bite the bullet and issue. Don't be afraid. And clients want my opinion. They don't just want me to say, well, you do this, and if you do this, this. Yeah, but what's your hunch? What's your gut instinct? I've never been sued yet. Had a complaint yet, of having given honest advice to someone and it having not worked out. Lawyers get into trouble with complaints and negligence claims from making mistakes and from being in denial about making mistakes. That's what your client wants. They want the lawyer to tell them what they think, what their opinion is, and then they can make up their own mind whether to take it. I think you should not, put it this way, you should not be afraid to issue and mediate afterwards. Because it's the fear phantom is far bigger than the actual little mini balloon bubble in terms of the risk of a judge down the track saying, oh, you didn't mediate pre-issue, therefore I'm going to slap you with a large adverse costs order. Right, can I sue a bank for harassment? Yes, because one of our clients did, litigating in person, and I was like, I don't think you know this is harassment. Banks phoning you day and night, debt collectors hounding you and chasing you, but he managed to win, and it didn't go to trial. Unfortunately, that would have been fun, but it's settled because here's a case where the bank incompetently dealt with defending the claim, and he's quite experienced. For a litigated person, he'd run a few other cases, and he knew what he was doing, and he had our legal advice in the background, and so he managed to get a result which was terrific, because there's nothing better than getting one over on the banks, is there? How does a court wingman surgery work? Read the welcome email. That's how it works. Put your documents into apple pie order, reverse chronological order, if possible, into one PDF so we can skim read it during the 1 hour legal surgery. We're not giving you for £150 combined litigation experience of 40 plus years. We're not giving you that rate to then read through a huge quantity of documents as well. And really, that's how a court surgery works. Nice couple of opening paragraphs. What is the claim? The story of the claim, possible quantum, and any relevant history of proceedings. Is it issued or not issued? And then attaching a PDF in reverse chronological order. That will then prepare you for what's to come. Yeah, we're not just doing it to be annoying. We're doing it because we want you to learn the importance of discipline in respect of your paperwork. What's the difference between pleadings and evidence? The reason why this is an important issue is because a lot of litigants in person load up their particulars of claim with evidence. You know, I've seen emails, letters, all sorts, yeah? The statement of case phase, or pleading is the old-fashioned term, the particulars of claim, defence, counterclaim, reply, yeah? They should very rarely have attachments. They should just lay out the skeleton of what has happened, the case, the story of the case in chronological order, preferably. Not in all cases, but if you're a litigant in person, best to stick to a simple chronological order. Tell the story of the case. Evidence comes later. There's a whole separate phase for that. In a small claim, there's exchange of witness statements, let's say. There's not a disclosure phase in small claim. There is a disclosure phase in other cases. That's when evidence is exchanged between the parties, and then after that comes witness statements. So be careful. If a court, the more concise you can be with the claim, the more you'll win over the judge. They'll love a professionally presented person in court. And judges are human. Those sorts of things do sway their decision. So that's why that question is there. Cohabitation, property disputes and contested wills, there are specialist areas, and so I just wanted to give you a couple of golden nuggets of litigation knowledge. Contested wills, I think you definitely do need a lawyer. Because of the Chancery Division, because, you know, do you know what a warning is, a caveat is? Do you know much about what a grant of probate is? Do you know the protocol of warning off a caveat? I mean, wills cases, the cause of action are complex in terms of, you know, whether it's undue influence or lack of knowledge and information, or, you know, there's a plethora of different angles on a wills case. That means you really need to have your particulars of claim properly drafted. Cohabitation, property disputes, also, I would not advise you running them without a lawyer. There's a possibility of no win, no fee in both those category of cases because there's usually a pot of gold, a property or an estate. So you might attract a law firm to enter into no win, no fee. Although, as I said earlier, not at the outset. They need to have eyeballed the case and believe in the case and believe in the client too. I've got a case at the moment where the possibility of no win, no fee has been raised, and I'm like, well, Alex, you know, he's paid his invoices up to this point promptly. He's thorough, he responds quickly, he gives us good information, good instructions. I almost now feel duty bound to offer no win, no fee. So the calibre of the client is also important when lawyers are considering running no win, no fee litigation. As I say, there are always exceptions, and one client just recently we've said we've turned him away actually because he didn't really have the money to go through the law firm in a traditional way, and he wants to run the case himself. This is what I mean about use a lawyer. Have a lawyer represent you, go on record, not just use courtwingman in the background. But as I say, in this wills case, we have turned him away because we don't think he can get together a big enough war chest in this wills case. We've told him that courtwingman is here if he needs us, and it will be interesting to see. He'll probably go to other lawyers who are cheaper, but he may run it himself, and it will be interesting to see how he gets on because he's quite a capable individual. So there is never a never. One of the first wills cases that we did that went all the way to trial, our client only got us involved in the traditional law firm respect after he'd nearly been struck out at a caveat stage. I think the opponent had warned off his caveat, and there was an appearance area hearing. and he was in danger of actually, you know, getting completely struck out. But he got us on board just in time. So, I mean, never say never, but I really don't recommend it, and definitely not in complex cases like defamation or trademarks and such like. Right, finally, how do I ask the court for something? Well, you fill in an N244. Pretty much everything under the sun that you could want from a court, whether you're bringing to the court's attention the fact that your opponent hasn't disclosed stuff that you think he ought to disclose, or you want to make an application to strike out, or you're not going to make an application to have an expert introduced. You need the court's permission for an expert to be introduced in proceedings. You know, pretty much everything can be covered by an N2444. And the reason you need to fill it in is because the courts won't do anything without money these days. So you have to put, I think it's £303 at the time of recording. You have to pay a court fee every time you ask the court for something by means of an N244. So in a way, that's part of the reason why you have to fill in the form so the court gets its fees. So a bit of a whistle-stop tour. I hope nevertheless it's enlightened you, and I do wish you the best of your case, and I do urge you to let us know whether you've won your case, lost the case, and to share the knowledge, because you know, I'm quite excited about this court wingman business, which has been growing. I'm excited by the idea that there's sharing of knowledge, you know, because you know what one court is doing, what one judge, even a judge, is like, maybe, what the delays are, what the how the courts are requiring people to engage with the courts. You know, for example, filing and megabyte limits when you're filing online at the court, and but also just what sort of judgments are being handed down, because there's nothing better than experience in the trenches in terms of being able to really provide the very best blue chip litigant in person, hands-on advice service that I aspire court wingman to be. Okay, folks, that's all for now.